Thank you for taking the time to learn a little bit more about my decision to join the multi-state lawsuit led by the Florida Attorney General's Office, challenging specific provisions of the federal health care law. Washington State is now one of 28 states challenging certain provisions of the law, and one of 26 in the multi-state suit. This lawsuit, filed in Florida in March 2010, challenged the unprecedented requirement that individuals lacking health insurance must have or purchase government-approved health care coverage from private insurance companies, or else pay a fine. The states believe this mandate violates the limited Commerce Clause powers of Congress, as well as the 9th and 10th Amendments of the U.S. Constitution concerning the powers of the states. On January 31st of this year, Judge Roger Vinson of the Northern District of Florida Federal Court ruled in favor of the states that the individual health insurance mandate is unconstitutional, stating, quote, "The existing problems in our national health care system are recognized by everyone in this case. There's widespread sentiment for positive improvements that will reduce costs, improve the quality of care, and expand availability in a way that the nation can afford. Regardless of how laudable its attempts may have been to accomplish these goals in passing the Act, Congress must operate within the bounds established by the Constitution." Close quote. This decision was appealed by the Department of Justice to the 11th Circuit Court of Appeals. On August 12, 2011, the 11th Circuit issued a 2-to-1 opinion, again ruling that the federal government may not force individuals to purchase government-mandated and approved health insurance in the private marketplace. The 11th Circuit differed from Judge Vinson on whether or not the entire law should be thrown out because one piece of it is unconstitutional. The court agreed with my long-held belief that the individual mandate could be found unconstitutional without throwing out the entire law. On September 28th, both the U.S. Department of Justice and the 26 states filed petitions for review with the U.S. Supreme Court, asking the court to rule on the constitutionality of the mandate and on its impact on the entire law. We hope they will take this case and issue an opinion sometime by late next spring. Healthcare reform is a vitally important issue in our country. Unfortunately, as Judge Roger Vinson points out, this federal healthcare law represents an enormous expansion of federal power unlike anything our highest courts have ever addressed. While there are provisions in the new healthcare law that I support, I also support expedited review of this case to bring greater certainty for all involved. Healthcare reform is much too important to build on an unconstitutional foundation, and it's possible to pass healthcare reform that is affordable and accessible without violating the people's rights. My office has received a tremendous amount of feedback on this issue, both supportive of and in opposition to the suit. These are issues of the utmost concern in our state and around the country. Regardless of the positions or viewpoints they express, it's important that Washington citizens are making their voices heard. I hope you find this information helpful and encourage you to find more information about this lawsuit right here on our website. Thank you very much.